William Osborne was tried and convicted of rape and assault in Anchorage, Alaska in 1993. The evidence against him included not particularly precise DNA testing available at that time. As a trial strategy, Osborne's attorney did not request the more conclusive DNA testing. Post-conviction, Osborne sought an even more precise DNA test that became available after trial. But he failed to win that right in state court under the U.S. or Alaska state constitutions. He then filed a Section 1983 suit in federal court, claiming a constitutional right to the DNA testing. He won in district court because of unique factors in his case. The tests were unavailable at the time of his trial, the new tests would cost the state almost nothing, and the results probably would be material. The appeals court for the Ninth Circuit affirmed. Alaska appealed that judgment, and the Supreme Court granted cert in District Attorney's Office for the 3rd Judicial District versus Osborne. Laurie, did the Supreme Court uphold the Ninth Circuit?
No, it did not. Chief Justice Roberts wrote this decision, and he basically said that denying the DNA testing in this case was neither a substantive due process violation nor a procedural due process violation. He noted that while DNA evidence can be very powerful, it's not the be-all or end-all, and it's really up to the state legislatures to have state statutes that will govern this. It turns out that Alaska is one of only a handful of states who doesn't have such a statute. So instead, it had a system and a rule set out by the courts that had a 3-part test. The defendant, in order to obtain this evidence, had to show that the conviction rested on eyewitness testimony, that there was demonstrable doubt as to those identifications, and the test was likely to be conclusive. Since the defendant couldn't meet that test in this case, he didn't get the evidence, and there was no due process violation.
The defendant also argued that under Brady versus Maryland, the state had the obligation to make the evidence available for testing. Chief Justice Roberts, writing for the court, rejected the application of Brady. He said, once there's been a conviction, Brady versus Maryland no longer applies. The presumption of innocence before conviction doesn't carry after the defendant has been convicted. Chief Justice Roberts then went on and emphatically rejected the idea of a due process right to evidence for DNA testing. As Laurie said, it doesn't matter whether it's called a procedural due process right or a substantive due process right. There is no constitutional right to have material available for DNA testing.
Okay, well, there's another aspect of this case, I believe, having to do with the 1983 action, right?
That's right. And basically, there are 3 justices who would bar this claim under Heck versus Humphrey, which says that you cannot challenge by civil suits a conviction until that conviction's overturned. Only 3 justices in this case, but they might get 5 down the road.
Well, it might be worth noting that this was a 5-4 decision, and with the dissenters believing that Alaska's denial of the DNA testing was arbitrary and violated both procedural and substantive due process, they believe that the liberty interest outweighed any state interest that it was in effect.
Well, one of the reasons they argued that is that, in fact, no defendant has been able to obtain this DNA testing under the Alaska statutes.
I think the bottom line is that whether there's a right to DNA testing is left to Congress and the state legislatures. It is a matter for legislation, not a matter of a constitutional right.
Okay, thank you. Well, it's not often that legal fiction and legal fact reflect each other as closely as they did in this next decision, but the plot of John Grissom's novel, The Appeal, and the facts behind Caperton versus A.T. Massey are surprisingly similar. A West Virginia jury awarded a $50 million verdict to Caperton in a suit against the A.T. Massey Coal Company. The company's chairman, Don Blankenship, supported Brent Benjamin for a seat on the state Supreme Court, spending $3 million on Benjamin's campaign. That was more than Benjamin's own campaign committee and all of his other supporters spent collectively. Benjamin won. Caperton moved to disqualify Justice Benjamin from sitting on the appeal under the Due Process Clause and the state's Code of Judicial Conduct. Justice Benjamin refused to recuse himself from the decision that reversed the $50 million jury award. The question before the U.S. Supreme Court was, does it violate due process for a judge to participate in a case when one of the litigants donated substantial funds to the judge's election campaign? Does it, Erwin?
The Supreme Court said it does violate due process. It was a 5-4 decision with Justice Kennedy writing for the majority. Justice Kennedy said the due process in the Constitution import the common law rule that requires recusal when a judge has a direct, substantial pecuniary interest. Justice Kennedy said the question is the risk of actual bias so great as to be constitutionally intolerable? It's worth here looking at the exact language that Justice Kennedy used in defining the standard for due process. He said, and I quote, that the issue is whether, under realistic appraisal of psychological tendency of human weakness, the interest poses such a risk of actual bias or prejudgment that the risk must be forbidden if the guarantee of due process is to be adequately implemented.
And then the court set out some factors to look at to see if it meets this test in the campaign contribution context. So you're looking at the relative size of the contribution, the total amount spent on the campaign, the effect of the contribution, the timing of the contribution. Certainly not required to prove that there was a quid pro quo or that this contribution did get the justice elected. And the court went out of its way to try to emphasize, in order to not open the floodgates, that this was an extraordinary case. On the other hand, it's a big question how they're going to limit this case and how the courts are going to apply these standards and tests.
Chief Justice Roberts wrote for the 4 dissenters, and that's exactly what he emphasized. He said, when there's a violation of due process is too ambiguous and vague after this case. In fact, he structured his dissent around 40 unanswered questions. He literally listed 40 questions that are open after this case, all of which ultimately go to the issue of where is the line to be drawn. $3 million in an election decided by 50,000 votes violates due process. But how much money and what kind of election will be enough to violate the Constitution? That's what's uncertain after this case.
I guess we're going to have to wait and see what happens here. Finally, our First Amendment decision. In Pleasant Grove City, Utah versus Summum, members of the Summum faith asked Pleasant Grove City to allow them to place a monument with Summum's 7 aphorisms in Pioneer Park. There are already 15 permanent displays in the park, 11 donated by private groups, including a large 10 Commandments donated by the Friends of the Eagles. Pleasant Grove refused, and Summum sued the city under Section 1983 for violating the First Amendment. Laurie, did it violate the First Amendment when the city refused to place the monument?
No, it did not. In fact, this was a unanimous decision, and it did not violate the First Amendment because the free speech wasn't violated because this was government speech, not the government endorsing or providing a forum for private speech. And so in this case, when there had been no Establishment Clause challenge, the court said it was upheld.
Laurie's right that the court emphasized that this is government speech, but that raises important and even troubling questions. First, it raises issues with regard to the Establishment Clause. Once it's said that the 10 Commandments monument is government speech, that heightens the concern, is this government's symbolic endorsement of religion that would violate the Establishment Clause? And second, it raises questions in terms of free speech. Imagine that there was a city with a park and it allowed a pro-war demonstration, and then it refused to allow anti-war demonstrators to use the same park. The traditional answer would be that clearly violates the First Amendment. But what if the city says, we adopt the private pro-war demonstration as our government speech, just like Pleasant Grove adopted the privately donated 10 Commandments monument as its government speech? Can it then engage in viewpoint discrimination? Justice Alito, writing for the majority, drew a distinction between a permanent monument and transitory speech, but it's hard to see why that distinction would matter in terms of free speech under the First Amendment.
And we see these concerns in the concurrences. You know, Justices Stevens and Ginsburg said they're not quite ready to buy into this, what they call the newly minted government speech doctrine, that there might be an implicit endorsement of the message by the government, and if so, we would look to the Establishment Clause or perhaps equal protection to bring those challenges. You have Justice Breyer writing that he says don't look at the labels, really look at what the cities are doing. And then Justice Souter has his own test where he says it's whether, quote, a reasonably and fully informed observer would understand the expression to be government speech.
Well, thanks, Laurie. Finally, one interesting note in this area of law. At the end of the term, the court put off for re-argument until September 15th, 2 weeks before the beginning of its October term, a case considering whether restrictions on corporate contributions to political campaigns violate the First Amendment. Suzanna Sherry, Evan Lee, and I'll be back in a moment. Our first decision, Ricci versus DiStefano, is generating much discussion for the changes brought about in employment discrimination law. The facts of the case, as you probably know, are that the New Haven, Connecticut Fire Department gave a promotion exam on which no African American and only one Latino candidate scored high enough to win a promotion. Fearing a disparate impact suit by minority firefighters that the exam was biased against them, New Haven canceled the results of the test and promoted no one. The city was then sued by the white and one Latino firefighters who had scored well enough on the exam to be eligible for promotion for violating their rights under, among other things, Title VII and the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. The district court granted the city summary judgment, finding that it had reason to be concerned it would be liable under a disparate impact analysis, and that it had made a prima facie case that it had not acted with discriminatory animus towards non-minority candidates. The appeals court affirmed the district ruling in a per curiam opinion that essentially adopted the lower court's reasoning. The question before the Supreme Court was, can an employer's concern for its liability under adverse impact analysis of an employment practice be a defense to a claim of intentional discrimination? Evan, can it?
Well, yes and no, depending on the basis for fearing that they would be liable. But let's define some terms. Title VII of the Civil Rights Act of 1964 forbids employers to discriminate in employment practices on the basis of race or color, religion, sex, national origin. And intentional discrimination is known as disparate treatment. Now, in 1991, Congress amended the law to add a prohibition against facially neutral policies and practices by employers that are in operation or in fact discriminatory. That was a codification of the Supreme Court's 1971 decision in Griggs versus Duke Power. That kind of discrimination is called disparate impact. Employers can defend against a disparate impact charge by showing that the challenged policy or practice is job-related and that it's justified by business necessity. And then if an employer can show that, the burden shifts to the plaintiff, who would then have to show that the employer had refused to adopt some kind of alternative practice that still served its need but would have a less disparate impact. So now to answer your question, the court held in Ricci versus DiStefano that an employer may engage in a race-conscious action to avoid disparate impact liability, but only where there exists a quote-unquote strong basis in evidence to conclude that such liability would otherwise have been incurred, and not just when an employer has a good faith belief that it would be liable for disparate impact.
Well, Suzanna, I think most of our audience knows by now that the court found for the white firefighter appellants. But can you tell us a little bit about their reasoning?
Well, they went into great detail about the facts in this case, about how New Haven had carefully constructed the test to make the questions job-related and to minimize the disparate impact, and had provided the materials, the study materials, to the firefighters and so on. And because of this history, the court found that the city did not have an objective basis, a strong basis in evidence, for believing that it would be liable under disparate impact theory because the tests were job-related and there was no less discriminatory alternative. By the way, the court took the objective basis, strong objective basis, in fact, test from equal protection cases where employers, government employers, are not allowed to use affirmative action unless they can show that there is strong evidence that the affirmative action is necessary to combat prior government discrimination.
Well, there were two concurrences and a dissent in this case. Can you tell us about those?
Well, the concurrences, one was by Justice Alito, who concurred to suggest that perhaps the reason the city had canceled the test was to appease a particular racial constituency. And then Justice Scalia wrote a concurrence because he thinks that the disparate impact analysis and the equal protection jurisprudence are on a collision course, and that eventually the court is going to have to deal with that collision.
Well, what about the dissent?
Justice Ginsburg wrote to say that she did not see disparate treatment and disparate impact as necessarily being in conflict with one another, but rather as being both parts of a unitary approach to guaranteeing equality in the workplace. And she predicted that the majority's decision would not have staying power.
Thanks, Evan. In our next decision, Gross v. FBL Financial Services, the court answered a question not raised by the cert petition nor briefed by the parties and changed the law in every circuit. Jack Gross sued his employer, FBL Financial Services, under the ADEA, the Age Discrimination in Employment Act. The question the court agreed to hear when it granted cert was if a plaintiff shows that age was a motivating factor, but not the only factor in making an adverse employment decision, what type of evidence suffices to switch the burden to the employer to show that it would have made the same decision without considering age? Suzanna, what kind of evidence did the court say was necessary?
Well, let me start by going back to what you said about changing the law in every circuit. Before this decision, there was a split in the circuits arising from the court's decision in Price Waterhouse. And some circuits said that you needed direct evidence of discrimination, discriminatory motive, to switch the burden. And other circuits said no, any evidence of discriminatory motive would suffice to switch the burden. But one thing all circuits agreed on was that if there was the right kind of evidence, the burden would switch to the employer to show that it would have made the same decision anyway. And what the court held was that no evidence is sufficient. The burden never switches.
Yeah, the majority criticized the Title VII burden shifting scheme, said that it was quote unquote difficult to apply. Instead, following the language in its 1993 decision in Hazen Paper versus Biggins, the majority said that in order for a plaintiff to prevail, that age had to have had a determinative influence on the outcome. In other words, you have to be able to say that, but for the consideration of age, that decision wouldn't have been made.
Okay, so if I'm understanding correctly, now people have two different standards depending on whether the action's brought under Title VII or under the ADEA. Is this right?
That's exactly right. The court distinguished between Title VII and the ADEA because Congress in 1991 amended Title VII to essentially incorporate the Price Waterhouse standard that says that race or gender could be just a motivating factor and didn't have to be the sole factor. But Congress didn't amend the ADEA, and so the court said that language would not be interpreted the same way. Basically, the bottom line is if Congress wants the ADEA and Title VII to be interpreted the same way, they're going to have to amend the ADEA.
Okay, well, what about the dissent in this case?
Well, you know, sometimes people question the value of dissents and say that they write too many of them, but the majority opinion in this case basically adopts Justice O'Connor's dissent in Price Waterhouse calling for this but-for standard in Title VII cases. And the dissent in this case by Justice Stevens and three others would have adhered to Justice Brennan's plurality opinion in Price Waterhouse that if any impermissible consideration played a part in the employer's decision, that the employer should be liable under Title VII. So who knows? Maybe someday this dissent will become the majority as well.
We'll see. Okay. Well, unlike the decision in Gross, our next three decisions reach conclusions that follow recent trends in Title VII and ADEA cases. Evan, what were the facts in AT&T versus Hulting?
Hulting argued that prior to the enactment of the Pregnancy Discrimination Act in 1978, that AT&T didn't treat maternity leave the same way it treated other forms of disability leave for purposes of, pension and other benefits. But you have to remember that discrimination was not, discrimination on the basis of pregnancy was not illegal under Title VII at that time because of a decision called General Electric versus Gilbert. Now, after the PDA was passed, AT&T adopted benefits calculations that did give service credit for pregnancy leave on the same basis as leave taken for other temporary disabilities. But AT&T didn't go back and retroactively adjust the calculations for women who had been subject to the previous policy. And because AT&T's seniority system calculated pension benefits based on length of service when employees retired, the women subject to the old policy had earned fewer benefits.
Okay, well, how did the court come down in this case?
They said there was no Title VII violation. Basically, they relied on the fact that the policy before the PDA was legal because it wasn't discriminatory, and that all of the results were, all of the effects came from as a result of a bona fide seniority system. And under Title VII, bona fide seniority systems are protected even if they have a discriminatory effect. And the seniority system was bona fide because it wasn't intentionally discriminatory.
Yeah, the court said it would have been different if the PDA had applied retroactively, but there was no evidence of congressional intent to that effect.
Okay, so Justice Ginsburg wrote a very strong dissent, as I recall, right?
She did, joined by Justice Breyer. She essentially said that the decision, the 1976 decision that Evan referred to in General Electric versus Gilbert, was not just wrong, but it was so egregiously wrong that when Congress changed it, the court should act as if it had never happened, and that basically any employment practices that were tainted by even pre-PDA pregnancy discrimination should be held to violate Title VII.
Okay. Well, let's turn to Crawford v. Nashville. In the past few years, the court has decided a series of cases on retaliation claims and has broadly interpreted various statutes to allow such claims. This case takes a similarly broad view of retaliation. Title VII protects employees from retaliation if they oppose any practice that Title VII makes illegal, or if they bring a Title VII suit or participate in a Title VII investigation or proceeding. Evan, which one of these protections was Crawford under?
Well, according to the lower courts, neither one.
Okay.
Crawford had been harassed by an employee of the defendant's school district, but she hadn't reported it until she was interviewed by an internal investigator who was looking into harassment charges against another employee. Although she was retaliated against for what she told the investigator, the lower courts initially held that she didn't qualify for protection under the so-called opposition clause on the theory that the opposition had to be active and consistent.
Okay. So what did the court hold, Suzanna?
It reversed unanimously, and it said that participating in an internal investigation is opposing illegal practices and therefore is protected by the opposition clause. And because it said that, it didn't have to go ahead and determine whether it was also protected under the participation clause.
Okay, well here, was there any disagreement among the justices?
On the broad rule, yes. There was a concurrence by Justices Thomas and Alito. They said that they would hold that opposition must be, quote unquote, active and purposive to qualify under the opposition clause, but they acknowledged separately that testifying in an internal investigation would qualify for that.
Okay. Our final decision in this segment is 14 Penn Plaza versus Pyatt. This was in keeping with another trend the court has established and followed over the years, the trend in favor of arbitration agreements. At issue was a collective bargaining agreement that required union members to arbitrate their claims under the Age Discrimination in Employment Act. The question was its enforceability. Susanna, did the court find it enforceable?
It did, but in order to find it enforceable, it had to narrowly construe some of its own prior precedent. The Second Circuit relied on some Supreme Court cases from the 1970s, including Alexander versus Gardner-Denver and its progeny, which seemed to hold that statutory anti-discrimination claims cannot be subjected to mandatory arbitration. And in this decision, the court said that Gardner-Denver didn't preclude arbitration as long as the specific statutory claim was explicitly made subject to arbitration in the collective bargaining agreement, as it was in this case.
Yeah, the court also says that the portion of the ADEA that requires the waiver of a substantive right to be knowing and voluntary doesn't apply in this case because what's involved here is the waiver of a judicial forum, not the waiver of a remedy.
I think this case is important for what it says going forward. The court suggested that if Gardner-Denver had not been distinguishable in this case, it might have been overruled because it was from a time when the court was unjustifiably hostile to arbitration. The court said that Gardner Denver's skepticism against arbitration rested on a misconceived view of arbitration that this court has since abandoned. I think that's a pretty strong signal that the court is going to distinguish or overrule any cases that exempt certain claims from arbitration.
Thanks, Suzanna. Thanks, Evan. We'll be right back. Three of the 5 civil rights decisions we're going to discuss involve 42 U.S.C. Section 1983. Under that statute, local governments and state and local officials can be sued for violating civil rights when acting under the color of law. When government employees are sued for money damages under 1983, they may be given either absolute or qualified immunity. Absolute immunity is the exception and is given for only a few tasks performed by employees. One of these is for prosecutors acting in their prosecutorial capacity. That was the focus of our first decision, Vanderkamp versus Goldstein. Tommy Lee Goldstein spent 24 years in prison for a murder he didn't commit. He was convicted entirely on the testimony of 2 witnesses. One of those later recanted, and the other was a police informant named, ironically, Edward Fink. Fink testified that Goldstein told him he committed the crime when they were cellmates in Long Beach, California. Fink denied he made a deal with prosecutors for better treatment in exchange for his testimony, but it later came to light that he had. Goldstein ultimately brought a successful habeas claim to win his release. He then sued the former district attorney and his chief deputy under Section 1983 for failing to train prosecutors to provide exculpatory material to defendants that they were required to provide under Brady v. Maryland. The question before the Supreme Court: was the suit against the DA and his deputy barred by absolute prosecutorial immunity? Suzanna?
It was. The court said it was barred by absolute immunity, but I think you have to understand the full importance of this case. You have to look at what Goldstein was specifically alleging in his complaint. He sued the DA and the deputy for 3 things: for failing to properly train the line prosecutors, for failing to properly supervise them, and for failing to create an information system to keep track of informants and keep track of necessary disclosures. So the failures here were not failures that were directly related to the prosecution of Goldstein himself.
And so, Erwin, why is that important?
In 1976, in Imbler versus Packman, the Supreme Court said that prosecutors have absolute immunity for their prosecutorial tasks, but only qualified immunity for their administrative or investigative tasks. The Supreme Court said that each of the tasks that Suzanna just referred to should be regarded as prosecutorial and protected by absolute immunity because they're ultimately all linked to what actually goes on at trial in the courtroom.
The court basically said that because the line prosecutors themselves would have been immune from suit for failing to disclose, the supervisors had to be immune for claims that they failed to train or supervise or create an information system. Basically, what the court said is that giving a cause of action without immunity for these sorts of things would be as disruptive of the prosecutorial function as allowing suits for things having to do with the prosecution of individual cases.
I think this case is part of a trend in the Supreme Court and the Federal Court of Appeals towards the expansion of the scope of absolute immunities.
Okay. Well, as I said before, officers who do not have absolute immunity are protected by qualified immunity when sued for money damages. Qualified immunity means that there is liability only if the officer violated clearly established law that a reasonable officer should know. In our next decision, Pearson v. Callahan, the focus was on the law used in the analysis of qualified immunity. In this case, Afton Callahan sued police officers for violation of his Fourth Amendment protection against unreasonable searches and seizures when they entered his home without a warrant. The officers raised qualified immunity as a defense. Erwin, what's the analysis here?
In a series of cases culminating in Saucier versus Katz in 2001, the Supreme Court prescribed a 2-step approach for trial courts to use in determining whether an officer is protected by qualified immunity. First, taking the facts in light most favorable to the plaintiff, the court is to decide whether there's a constitutional violation. And if so, second, then it was to decide is there a violation of clearly established law that the reasonable officer should know? The issue in Pearson versus Callan is, should Saucier versus Katz be overruled?
And how did the court come down on that question?
The court overruled Saucier. What they said is that district courts, judges can use their discretion in deciding in which order to analyze the question. So if it's easier, for example, to just determine that there is no clearly established constitutional violation, the court need not first determine whether there is a constitutional violation at all.
But it's important to emphasize the court did not prohibit trial courts from engaging in the two-step approach. It just said that the two-step approach is not required. It's interesting to think about what's this going to actually mean in the trial courts. On the one hand, in cases where a trial court can find qualified immunity, it can easily include there's not clearly established law, the reason law should know, it can be dismissed easily. On the other hand, it's going to mean a lot less development of constitutional law to provide guidance for trial courts into the future.
Yes, and this was a decision by a unanimous court. Yes. Okay, well now our last 1983 decision, Fitzgerald versus Barnstable School Committee. The issue here was whether the existence of a Title IX claim precluded a 1983 action. In this case, the parents of a kindergartner who was sexually harassed by an older boy on her school bus sued the school district for failing to adequately respond. Their complaint included a claim for violation of Title IX and claims under Section 1983 for violation of Title IX and the 14th Amendment's Equal Protection Clause. The appeals court ruled that the existence of a Title IX remedy precluded a Section 1983 suit. Did the Supreme Court agree, Suzanna?
No, they disagreed. There had been a circuit split before this case, and in this case the Supreme Court said that, unanimously again, that a 1983 action is permitted because Title IX is neither elaborate enough nor detailed enough to preclude a 1983 suit.
Okay, so when would a 1983 action be precluded by a federal statute?
The Supreme Court has consistently said that if a federal statute provides a comprehensive enforcement mechanism, it then precludes a 1983 suit. The key here is the Supreme Court said that Title IX is not such a statute. The Supreme Court said it doesn't allow suits against individual officers. The court said allowing a Title IX action won't, a 1983 action won't interfere with the Title IX administrative remedy. The court said there's no indication that Congress meant to preclude 1983 suits when it adopted Title IX.
Now, Erwin, isn't this decision a departure away from what the court's been finding in recent years, that 1983 actions are precluded by federal statutes?
You're absolutely right. All of the recent cases have found that specific federal statutes did preclude 1983 actions. Here the court said that Title IX does not preclude a 1983 action. But there's something different about this case. Here the issue was, would Title IX preclude a constitutional equal protection claim under 1983? In that sense, the greatest significance of this case is what the court didn't decide. Had the court found that a constitutional claim was precluded by Title IX, that would have really changed the nature of the law.
Okay, thank you. Next, we have a civil rights decision involving a statute other than 1983. This time it was Section 5 of the Voting Rights Act of 1965, which Congress extended for another 25 years in 2006. Section 5 requires jurisdictions with a history of race discrimination to receive preclearance from the U.S. Department of Justice before it can change an election practice. In Northwest Austin Municipal Utility District No. 1 versus Holder, a small utility district with an elected board sought relief from the law under a bailout provision available to jurisdictions in compliance with the Act over a 10-year period. If this relief was denied, it argued that Section 5 was unconstitutional because Congress's power was remedial and there was no longer sufficient race discrimination to require such a remedy. So, Suzanna, did the court hold Section 5 unconstitutional?
No, it didn't, but it's not quite that simple. The court never actually reached the constitutional question. The court instead held 8-1 that local governments are eligible for this bailout provision. And just as all political units, including local governments, are considered political subdivisions for purposes of the preclearance requirement, the court held that they had to be considered political subdivisions for purposes of eligibility for the bailout. And the lower courts had said that the local governments were not eligible for the bailout. So what the court did was decide the case on statutory grounds and then invoke the canon that it doesn't reach constitutional questions if it doesn't have to.
Okay, so that's it. It's Section 5 is safe from constitutional challenge?
No, not at all. Chief Justice Roberts, writing for the majority, expressed great doubts about the constitutionality of the 25-year extension of Section 5 of the Voting Rights Act. He said it's a great intrusion into state and local governments. He said it's only justified to remedy intentional race discrimination. In fact, I thought it interesting that none of the justices wrote a separate opinion to defend the constitutionality of the extension of Section 5 of the Voting Rights Act.
The court actually went to quite some length to question the constitutionality of the statute. They suggested, noted all of the things that had changed in covered jurisdictions since the statute's enactment. For example, they pointed to the high registration rate among black voters, the rarity of blatant discrimination, the prevalence of both minority candidates and successful minority office holders, and then finally that there was often equivalent turnout in covered and non-covered jurisdictions.
I think what you're going to see is local governments are going to come to court and argue that they're entitled to a bailout because they don't have a history of recent race discrimination in voting. If they're denied the bailout, then they're going to bring the constitutional challenges to the extension of Section 5 of the Voting Rights Act.
I agree, and I think that Section 5's supporters should see this case as a warning shot across the bow, that essentially the Supreme Court is suggesting that if more bailouts are not granted, the court might well hold Section 5 unconstitutional.
I don't think there's any way to know at this point whether there'd be 5 votes to invalidate Section 5 of the Voting Rights Act.
Well, you noted this was an 8-to-1 decision. Who was the lone dissenter?
That would be Justice Thomas. He believed the court should have reached the constitutional question, and he would invalidate Section 5 because he thinks that the conditions that justified it originally no longer exist.
Thank you. Our next decision is Horn v. Flores. This was a case with a complicated procedural posture, but one that could have an important effect on institutional reform litigation. Some parents in Nogales, Arizona, filed suit in federal court alleging that the Nogales schools were providing inadequate instruction for students for whom English is a second language. The district court issued a declaratory judgment and an injunction in plaintiff's favor, and the defendants did not appeal. The state legislature increased the funding for the programs, but the district court declared there was no rational connection between the new funding levels and the needs of the students. The district court held the state in contempt until it complied with the injunction. The state moved to purge the contempt finding and to modify the injunction under Rule 60b-5 of the Federal Rules of Civil Procedure. Rule 60b-5 permits a party to seek relief from a judgment or order if a significant change in either factual conditions or in law renders continued enforcement detrimental to the public interest. Arizona argued that passage of the federal No Child Left Behind Act and improved teaching methods changed the facts on the ground and brought the state into compliance with the court order, even if funding levels did not satisfy the court. The question before the Supreme Court was, should the injunction have been modified on these grounds? Erwin?
The Supreme Court said there was a basis for consideration of modification of the injunction. The Supreme Court said that the district court and the Court of Appeals were much too restrictive in what they're willing to allow to be a basis for modification. The Supreme Court said it's important in an institutional reform case like this, where injunctions can exist for decades, to have a much more flexible approach is when injunctions can be modified.
The court also pointed to the Equal Education Opportunity Act, which is the act under which the suit was brought, and said that that only requires schools to take appropriate action for the targeted education population, and it doesn't provide for specific funding levels. So the court said that the courts below erred in looking only at the funding levels instead of looking at all of the changes to determine whether there was appropriate action being taken. In general, the court said that lower courts should take a much more flexible approach to modifying injunctions in order to return control to the local authorities as soon as possible. So the court ultimately remanded back to the lower courts for consideration of various factors to determine whether the injunction should be modified.
And I think that's really what's important about this case, and it transcends just the area of education. I think the Supreme Court was sending a clear message that it wants more flexibility is when these long-term injunctions can be modified. They want changes in fact or law, much more easily a basis for modifying these injunctions.
Thanks, Erwin. Thanks, Suzanna. Mark will be back with Suzanna and Evan to look at the court's decisions in the areas of federal jurisdiction and preemption.
Welcome back for the final panel of our program, this one on federal preemption and jurisdiction. If the term last but not least ever applied, it may be here because these may be some of the most important decisions of the term for the day-to-day work of federal judges. We start with two preemption decisions, Altria Group v. Good and Wyeth v. Levine. Both are about federal labeling laws and state causes of action, and both are good examples of how federal preemption jurisdiction is in flux. The Altria Group is the parent company of the tobacco giant Philip Morris USA. The respondents in this case originally charged that in advertising that some of its cigarettes delivered less tar and nicotine to smokers, while knowing that wasn't true, Altria engaged in fraudulent advertising in violation of the Maine Unfair Trade Practices Act. The district court granted summary judgment to Altria on the ground that the state law claim was preempted by the Federal Cigarette Labeling and Advertising Act. The Court of Appeals for the First Circuit reversed that judgment, concluding that the respondent's claim was not the kind of smoking and health-based state claim that the federal act was specifically meant to preempt, but was a state law fraud claim alleging Altria falsely represented their cigarettes. Susanna, where did the Supreme Court come down on this one?
Well, to answer that, let me take us back for a little bit of background. In 1992, the Supreme Court splintered over a very similar question in a case called Cipollone versus Liggett. In that case, there was no majority opinion, but the plurality adopted a test that focused on the legal duty underlying the state common law claim. If it was a general duty, then the claim was not preempted, but if it was a duty that was targeted at smoking and health, then it was preempted. So the court in Cipollone held that a fraud claim was not preempted, but that a claim based on a state law against advertising that minimized health risks, that would be preempted. Now in this case, the court adopted that majority of the court adopted that plurality standard and said that because the common law fraud claim in this case is not targeted, it's a general duty, the main claim was not preempted. The majority said that its preemption line might not be elegant. They said, in fact, it was inelegant, but it is straightforward. The question is the state law targeted at smoking and health, or is it general?
Right. The majority here distinguished its decision last term in Regal versus Medtronic on the ground that the state tort claim in that case was precisely the type that Congress meant to preempt. It then rejected the implied preemption claim here on the ground that the government denies ever having authorized the use of this light or low tar as descriptors.
Now, there was a dissent in this case, and the dissenters wanted the court to abandon the legal duty test altogether, and instead they wanted a proximate application test, which would preempt any state claim that imposes an obligation because of the effect of smoking on health.
But the majority said that that would allow a result that Congress could not have intended, namely to permit cigarette manufacturers to engage in fraudulent advertising.
All right. Now, in Wyeth v. Levine, the state law cause of action was for inadequate warnings on the label of a prescription drug. Diana Levine was a musician vacationing in Vermont when she went to a local health clinic seeking relief from a migraine headache. The clinic gave her Phenergan to relieve the nausea that accompanies migraines, but rather than giving it to her by IV drip, the physician's assistant gave it to her using the IV push method, where the drug is injected directly into the patient's vein. The danger there is that the drug is corrosive and causes irreversible gangrene if it enters the patient's artery. That's what happened to Levine, and her right arm had to be amputated below the elbow. In addition to the pain and suffering, Levine incurred substantial medical expenses and lost her livelihood as a professional musician. She settled with the clinic and the clinician and sued Wyeth Labs. While Phenergan's label warned that the dangers of gangrene and amputation following contact with arterial blood, Levine alleged that the label was defective because it failed to tell clinicians to use the IV drip instead of the IV push method, and that Phenergan was not reasonably safe for intravenous administration because of its foreseeable risks in relation to its therapeutic benefits. A jury awarded Levine more than $7 million in damages, but Wyeth contended before the U.S. Supreme Court that Levine's state law claim should have been preempted for two reasons. First, that it would have been impossible for it to comply with the state law duty to modify Flanagan's labeling without violating the federal law, and second, that recognition of Levine's state tort action creates an unacceptable obstacle to the accomplishment and execution of the full purpose and objectives of Congress. Evan, where did the court come down on these questions?
The majority rejected both of Wyeth's arguments. The majority held that it was not impossible for Wyeth to satisfy both state and federal law because it could have unilaterally strengthened the warnings against the administration of Flanagan by Ivy Push. The FDA permitted interim use of stronger warning labels without pre-approval, and there was just no reason to believe that the FDA would have disapproved the stronger warning labels.
I think the impossibility question was the easier of the two. It was a little more complicated when the court analyzed whether the tort suit created obstacles to congressional objectives. There was no evidence that Congress wanted to preempt these sorts of state tort suits, but the preamble to a 2006 FDA regulation did state that label approval would preempt. So the court held, the majority held, that FDA regulations can sometimes preempt, but that this one didn't. First of all, although they will sometimes defer to an agency, especially on areas of technical expertise, the ultimate decision on preemption is the court's to make. And they found that in this case, the preamble did not effectively preempt and did not deserve deference because first, there was no opportunity for notice and comment. Second, the preamble was at odds with the perceived congressional purpose, and also the preamble reversed a long-standing FDA policy without any explanation for the reversal.
Yeah, the majority here distinguished its 2000 decision in Geyer versus American Honda, where it held that state court claims for failure to install airbags were impliedly preempted because in that case there was an agency regulation that had the force of law, which was not present in this case.
I think it's important to mention that Justice Thomas concurred in the judgment but not in the reasoning. He did not like the majority's focus on congressional purpose. Instead, he would have limited preemption to either where it's impossible to comply with both or where there is an explicit textual basis for a preemption. So it sounds like he's going to be very unlikely to find implied preemption in the future, although of course in the Altria case he found textual preemption when there was, I think, a somewhat ambiguous text.
There was a dissent in this case by the Chief Justice and Justices Alito and Scalia. They argued that the Geyer approach ought to be followed because, in their words, juries are ill-equipped to perform the FDA cost-benefit balancing function.
Do these two decisions taken together tell us anything about the state of preemption jurisprudence?
I think they do. Before this term, the court has increasingly found state claims to be preempted, and in fact they have emphasized the plain meaning of the text rather than the congressional objectives, and they had before this term moved away from the presumption against preemption, and I think they reversed both of those in this term. They focused more on the congressional objectives than on the text, and they seem to invoke the presumption against preemption. So, as you said in the beginning, I think this is in a state of flux.
All right. Let's move on to our jurisdiction decisions. The most important of these may be Ashcroft v. Iqbal, with its clarification of the new pleading standard. Javaid Iqbal was a Pakistani Muslim arrested in the U.S. on criminal charges and held by federal officials following the terrorist attacks on September 11, 2001. Iqbal sued former Attorney General John Ashcroft and FBI Director Robert Mueller, claiming he was mistreated during detention and that the mistreatment was on account of race and/or religion. The district court denied the defendant's motion to dismiss on qualified immunity grounds, and the Court of Appeals affirmed. Let's look first at the Supreme Court's holding in this case and then talk about why it is an important decision in the area of federal jurisdiction. Evan, what did the Supreme Court hold in Iqbal?
The court held that Iqbal's allegations against Ashcroft and Mueller were insufficiently factual and they were too conclusory to survive the so-called plausibility pleading standard that the court adopted in its 2007 decision in Bell Atlantic versus Twombly. The court said that Iqbal's claim that Ashcroft and Mueller, and here I'm quoting, knew of, condoned, and willfully and maliciously agreed to subject plaintiff to harsh conditions of confinement solely on account of his religion, race, or national origin, end quote, constituted nothing more than legal conclusions unsupported by factual allegations.
Okay, so Suzanna, let's get back to Twombly. How does the court's ruling in Iqbal affect that?
Well, Twombly 2 years ago said that a complaint has to state a plausible claim to relief in order to withstand a motion to dismiss. And the two open questions after Twombly were, first, does it apply beyond the antitrust context? And second, what does plausible mean? And in this case, the court first made clear that it does apply beyond the antitrust context. That is, that the Twombly plausibility standard applies across the board in all causes of action. And in clarifying what plausibility meant, I think they ratcheted up the requirements for a complaint a bit. They recited established doctrine that for the purposes of a motion to dismiss, the court has to take factual allegations as true, but not legal allegations. And what I think they did was somewhat blur the line or move the line between factual allegations and legal allegations, because they said that a legal allegation includes a recital of the cause of action supported by mere conclusory statements. And they put into this category of insufficient legal statements rather than factual allegations the fact that Ashcroft was the principal architect of the policy, that Mueller was instrumental in implementing it, or as Evan noted, that both of them condoned it.
Yeah, the court held that to prevail, the complaint would have had to have contained facts plausibly showing that Ashcroft and Mueller purposefully adopted a policy of selecting their detainees based on race or religion or national origin.
Yeah, I don't think this is over. We'll have to see where the court takes this new standard, but it does seem to be inching a little bit closer to a probability standard rather than a plausibility standard.
We should probably also point out that in clarifying Bivens law, the court rejected supervisorial liability when it's based on nothing more than knowledge and acquiescence in the unconstitutional conduct of underlings. In other words, each government official, regardless of title, is responsible only for his or her own misconduct.
That's true, but I think there's some ambiguity about whether the court thought it was changing the law or merely restating existing law.
All right. Now we have a couple of decisions dealing with Court of Appeals jurisdiction. In Arthur Anderson v. Carlisle, the court again delved into the enforceability of arbitration agreements under the Federal Arbitration Act, an issue that often comes before the court in one form or another. The Federal Arbitration Act, or FAA, has two provisions regarding when a court may stay litigation. Section 3 authorizes a district court to stay any litigation that is arbitrable, and Section 16A authorizes interlocutory appeals of any order refusing a stay under Section 3. What was the issue here, Suzanne?
Well, Arthur Anderson wasn't a party to the contract that had the arbitration clause in it, but it moved to enforce that arbitration clause as a third-party beneficiary under principles of equitable estoppel. The district court denied the motion, denied the stay, and Anderson appealed. And the appeal was dismissed on the theory that stay motions based on equitable estoppel do not constitute motions under Section 3 of the FAA.
And did the court agree with that theory, Evan?
No, it rejected it. The district court had denied the stay, and the Court of Appeals had dismissed it on the theory that Susanna just enunciated. But the Supreme Court in this decision held that Section 16A authorizes appeals from any refusal of a requested stay and said that appellate courts should not, quote unquote, look through the motion to the merits of the appeal. Court said that nothing in the FAA blocks third parties from seeking to enforce arbitration clauses. The questions of who is bound by a contract and under what equitable principles is governed by state law. So the court remanded it for a decision whether Anderson would be entitled to enforce this contract under state law.
The court was sensitive to the possibility that there might be some frivolous appeals, but it said there were other ways to deal with it. For example, by streamlining the disposition of meritless claims, by authoring the district court to retain jurisdiction, or even by imposing single or even double costs as a sanction.
All right. Now, the court decided another case involving the FAA this term, this time focusing on Section 4, which allows a U.S. District Court to entertain a petition to compel arbitration if the court would have jurisdiction, save for the arbitration agreement, over a suit arising out of a controversy between the parties. Evan, what was the court asked to decide in Vaden versus Discover Bank?
Well, the court considered two questions involving a district court's jurisdiction over a Section 4 petition. First, should the court, if asked to compel arbitration pursuant to Section 4, quote unquote, look through the petition and grant the requested relief, if the court would have federal question jurisdiction over the underlying controversy? And the second issue was, if the answer to that first question is yes, may the court exercise jurisdiction over a Section 4 petition when the petitioner's Section 4, or when the petitioner's complaint, rather, rests on state law, but an actual or potential counterclaim rests on federal law.
And what did the court decide?
The court said that courts can look through the petition to see and compel arbitration in a case pending in state court if and only if the federal court would have jurisdiction over the dispute over a suit arising out of the controversy between the parties.
Yeah, the majority interpreted controversy between the parties to mean the substantive underlying conflict and not the dispute over the arbitration clause that's raised by the petition to compel arbitration.
But even for that dispute, all of the usual rules of federal jurisdiction apply. And so in answer to the second question, the court can only take jurisdiction if there is a federal question in the complaint and not if there is a federal question that is raised by a counterclaim. And that was the situation here. It was a counterclaim, and so there was no jurisdiction.
All right. Now, in our next case, Enken v. Holder, it asks what criteria an appellate court should use in staying the removal of an alien from this country. Is it the more restricted statutory standard governing injunctions that is in the Illegal Immigration Reform and Immigrant Responsibility Act of 1996, or the traditional criteria governing stays? Jean-Marc Enken sought asylum in the United States and deferral of removal, claiming that he would be persecuted if he returned to Cameroon because of his past anti-government activity there. His application was denied. After rounds of litigation, he appealed to the Fourth Circuit and asked that that court stay his removal pending appeal. The Fourth Circuit denied the stay, and Enken asked the Supreme Court to resolve a split among the circuits on what standard governs a request for a stay such as this. Evan, which standard did the court say is the right one?
The court agreed with Enken that the traditional four-part test for granting stays pending appeal should be used by the appellate courts. The majority said that it really came down to whether the statute's use of the word enjoin includes stays, and the majority said that it did, or rather that it did not, because injunctions stop people and stays only stop judicial proceedings.
So what's the traditional four-part test?
Well, under that test, an alien bears the burden of showing that there's a strong likelihood of success on the merits, that there will be irreparable harm if the stay is not granted, that there will be no substantial injury if the stay is granted, and that the balance of the public interest favors granting the stay.
I think it's important here that the majority, and especially a concurrence by Justices Kennedy and Scalia, emphasize that stays are not to be routinely granted, that removal is not automatically to be considered irreparable injury, that irreparable injury is not itself sufficient for a stay, and that a court has to give some weight to the public interest in removing aliens who are lawfully deemed to be removable.
I agree with Evan. I think courts of appeals should take this case as something of a warning not to grant stays too freely, and in fact as a suggestion that perhaps some courts of appeals have been granting stays too freely.
Oh, interesting. For a small legal principle and a unanimous result, this next decision generated some major disagreements that may yet lead to major changes. The case is Carlsbad Technology v. HIF Bio. Both state and federal claims were raised in state court and then removed to federal court. The district court dismissed the federal claim under Rule 12b-6 and then declined to exercise supplemental jurisdiction over the state claims under Section 1367C. So the state claims were remanded back to the state court. The defendant appealed, but the appellate court said that it had no jurisdiction because the remand was based on lack of subject matter jurisdiction by the district court. So what was the judgment that all of the justices could support, Suzanna?
They reversed unanimously because they agreed that the remand order was, in fact, reviewable. Section 1447D says that remands are not reviewable by appeal or otherwise, but the court's earlier precedent in the Thermtron Products case limits that to remands on the basis of Section 1447C, including lack of jurisdiction, which might have been at issue in this case. But in this case, it wasn't a lack of jurisdiction. It was the district court's decision to decline the exercise of jurisdiction, and so for that reason, the remand was reviewable.
Yeah, that means that all remand orders based on abstention grounds are not jurisdictional and therefore are reviewable.
For a pretty straightforward case, there were a lot of skirmishes in the concurrences, weren't there?
Absolutely. Justice Scalia wants to overrule Thermtron and take a strict textual approach. Justice Stevens agrees with Scalia on the textual reading, but applauds the court for sticking with precedent. And Justices Breyer and Souter want Congress to completely re-examine sections 1447C and D.
So I don't think we've heard the last of this question.
All right. Well, thank you, Suzanna. Thanks, Evan. Now here's John Cook with some final words.
That's our program for this year. We hope you found it interesting and helpful. We ask you again to fill out the evaluation form included with our online written materials and fax it back to us so we will know what you thought of the program and how we can improve it. I thank our faculty for helping to explore and explain this term's decisions and everyone here at the FJC who worked on the program. I'm John Cook. Thank you for watching.